Hey everybody, this is Paul Godfrey. Hope y'all are doing well. I'm a Florida attorney. This is not legal or investment advice. It is for educational purposes generally. Hopefully you also find it entertaining. I'm going to go ahead and get started on the Craig Wright case because it's interesting to me, and I think other people might like to know what's going on. But before we do that, some basic backgrounds. I'm going to cover a bunch about civil litigation in a very short time period, be very brief about it, because the two cases that I'm interested in are both, as you see here, Kleiman v. Wright, that's the Craig Wright case, and then also the Ripple case. Not getting into the Ripple case yet, but I will be able to provide you information on it so you have a basic understanding of what's going on. Hopefully, if this first one goes well, we can see what happens with the second one. I've already downloaded the documents for the Ripple Lab case. Well, a few of the basic ones, read through it. There's a lot of unpacking and a lot of unwrapping to do. So the first thing we'll go over, just a quick rundown on civil procedure. Generally speaking, in law school, you have a civil procedure class. That's what these two cases are, and it gives you, how actually litigating a case works from start to finish. So right here, you've got the parties, Kleiman v. Wright. And then in the second one, you've got Zakhanov et al. V. Ripple Labs Inc. So, and the person in the first area is generally considered the plaintiff or the petitioner. So Kleinman is the plaintiff in this case, and the person after the V, the versus, is the defendant. And that's enough to get started now. When I tell people about court cases, I generally tell them to think about it as not just two people arguing, but the judge is there too. So think of a teacher disciplining two students, and ultimately the judge has to deal with two kids who can't get along as grown-ups. So the judge is there to be like, hey, shut up, tell me what's going on, don't waste my time, do what I say when I say do it, then leave me alone, because I got a lot of other court cases on my docket, thousands of cases to deal with, and now I've got to deal with your problems too. So that's generally how things work. So these are both federal cases. So first I'm going to go up to a very brief rundown on the Federal Rules of Civil Procedure, most recently updated December 1st, 2018, I believe. So just going over the table of contents real quick, you will see generally how a court case works. I'm not going to go into all the details, but generally scroll down, historical notes. You've got three areas I'm going to focus on. Pleadings, right here. Disclosures and discovery, and then trials. So you can get a general idea of where this case is at, the Craig Wright case, the Kleiman v. Wright case, the Ripple Labs case is at, so you can get a general idea of how these cases are progressing. Actually, they're both the Wright case is further on, but the Ripple Labs case is still very in its very initial phases. We're not going to go over service of process and pleadings. Service of process regarding basically this first rules 3 through 6 right here. But basically all I need to know is that in short, service of process is when somebody comes up and says, hey, you have to go to this court, and we need to make sure that it's fair, that you have notice of this action so you can defend yourself. Basically, service of process is the way the kid A says, hey, kid B, you get in here so the teacher can tell us what to do, because you were a meanie and you stole my Legos, and now I want my Legos back. We'll get back to that later regarding one of the causes of action. But anyway, pleadings and motions. We've got the complaint, and let's go scroll down there. So on to pleadings. Disclosure statement. General rule of pleadings. Where are we? There we go. So, generally speaking, there's a complaint. That's where kid A is like, hey, kid B stole my Legos. And so what the judge will say, or the teacher will say, okay, what's your complaint? Kid A, what do you have to say? What Kid A has to say is, this is what happened, and that's the complaint generally. And then the judge says, okay, Kid B, how do you respond to what Kid A said? And he said, well, no, I didn't take his Legos. And that's generally the way that works. Those are pleadings. Well, the judge's job is to figure out what's going on. So after the pleadings phase, you have discovery. Discovery is just what it sounds like. It is facts being made known. They've got things like request for production, request for admissions, deposition, some of my favorites, interrogatories, you see that right there, producing documents as a request for production, request for admissions are down here, and then, well, the purpose of discovery generally is basically the court's like, all right, Kid A said Kid B took his Legos, and Kid B says, no, I didn't take those Legos. So how are we going to figure out what's happened? The court only wants to know exactly what happened. So the discovery rules are meant as a way for Kid B to say, hey, you have to give all the information to the judge. Same thing for Kid A. They're equally applicable to both parties. So basically Kid A and Kid B get to say, well, hey judge, this is what happened. Because ultimately the judge is this teacher being like, oh, why are you here in front of me? Why am I figuring this out? Okay, well, first I had to figure out what happened, and then after I figure out what happened through discovery, we can actually, go to trial on that point. And we're not even at the trial yet. But if you look at, a court case is a big funnel. At the very top, you've got pleadings, and then as you go down the funnel with discovery, it narrows the issues and gets smaller and smaller, ultimately until you get to trial, which is the very tip. And then that's what pours out to the very end, information that's basically distilled. This is what happened. These are the findings of fact, and this is the application of law. So that's a very brief rundown of civil procedure, which usually takes, a semester in law school. Like just in short, again, very brief rundown. But that's enough for now. So we're going to go to the case summary without further ado of Kleiman v. Wright. Well, here, before we even do that, we'll go to the docket. Went on to PACER. PACER is the federal court document system where you get to see, what's happening in a specific case. So this is the Kleiman v. Wright case, and the complaint was filed in February 2018. Summons returned, so service was completed by here. Extensions of time, they amended the complaint and changed it. Oh, they've got amended complaint. I have the regular complaint. Great. Well, we'll go over the amended complaint in another video. Motion to dismiss, and then eventually we start getting into discovery later on. Well, we still have to have an answer, so here's the answer to the amended complaint that happened in January of 2019, almost a year after the case was initially filed. Another amended complaint, second amended complaint potentially, ultimately changing what they're saying, and then you're going to start getting to discovery soon. So beginning of 2019, you're seeing discovery, and hearings on discovery start. So that's where we're at now. We're in the discovery phase on this case. So let's go to actually, just so you get a bit of background, you know what's going on. This is the case summary, and you can see these are some actually very, very hard hitters as it comes regarding to attorneys in the state of Florida and New York. I actually pulled up pictures of all of them. So for the plaintiffs in our case are, again, I have the complaint. I'll have to go ahead and get the amended complaint to basically redo the causes of action, but that's besides the point. So you've got Ira Kleiman, who's a purple representative of the estate of Dave Kleiman, versus Craig Wright. And so the initial complaint is the estate of Dave Kleiman, who has passed away, versus Craig Wright. You all know Craig Wright and probably already have an opinion of him. I don't want to be sued for defamation, so I'll let the documents and court documents speak for themselves. I'm not making any statements about him. So anyway, these are the people representing. Stephen Zach represents the plaintiff. We also have, so I presume probably the amended complaint actually most likely includes this second plaintiff, which is W&K Info Defense Research. We'll get to that in a bit. They're probably added as a plaintiff in the amended complaint. And the initial complaints were filed by Kyle Roach and Devin Friedman. So Stephen Zach, he's for the plaintiffs here, president of the ABA, practicing 30 years. Same thing, Andrew S. Brennan, former president of the ABA here, so that's a huge position. Andrew Brennan, and he's also a heavy hitter. You have these two younger attorneys who most likely got the case and now are getting referral fees, but also working on it. You can see that they have interest in digital assets, etc. Smart kid here. I could say kid. He only graduated a year after me, but he the highest score on the Florida bar exam in 2012. The year after I did, I didn't get the highest score in 2011, so congrats to him. And then you've got the attorneys for the defendant here. So if we go to we're done with the docket for now. Case summary. You've got, here we go, all these people. They're all from this Rivero Mestra, I'm probably mispronouncing that, law firm. The Schooner person, Schnur, no longer works there, so, well, no longer represented by them most likely, but here are the defense attorneys. It's the head of it. He's been practicing for 32 years. Anybody's been doing for something for 32 years has been doing something right. She's got 20 years of experience in Amanda McGovern. This guy is probably the hardest hitter, I would say. Over 30 years, high-profile cases and antitrust. Anytime you see anybody litigating antitrust, you know they're smart. You know what they're doing. Intellectual property, that's another hard one. RICO, securities. Securities are very difficult also. Then you've got this lady here, primarily on complex commercial litigation, complex being because there's now two plaintiffs in the case, and then also Brian L. Penshaw, a younger gentleman, graduated the same year I did, but he's won some awards and accolades also. Point is, all these people very, very good at what they do. So these are some pretty heavy hitters, especially if you look at this gentleman. Maybe it's self-advertising, but he's currently pursuing over $10 billion cryptocurrency case on behalf of the estate of David Kleiman. That's this case we're talking about right now. So he's young, but he's got some good clients and he knows what he's doing. Same thing for that gentleman. But let's go ahead and get rid of these tabs so we can go ahead. So these are people who are signing and working on both sides of these cases. So what is coming up next? We've got all right, let's get to the complaint. Again, I need to go over the amended complaint because I only went through the complaint initially. I'll do a short follow-up video on that. But let's go over. So most complaints are done the same. You've got an introduction, which gives you the gist of it. Basically, the rightful ownership of hundreds of thousands of bitcoins and valuable intellectual property rights of various blockchain technologies. I'm not sure about that second part. One of the things in here that the complaint alleges, again, it may not matter because there's been amended complaints, and whenever an amended complaint is filed, it overtakes the prior complaint and controls, unless, generally speaking, at least in Florida courts, there's a specific reservation of we're reserving allegations 1 through 3 in the complaint. So this may all be overridden by the amended complaints that were later on filed. Here is the gist of it. It is undeniable, however, that Craig and Dave were involved in Bitcoin from its inception. They both accumulated vast wealth from 2009 to 2013. This is the introduction. So, unfortunately, Dave died, and then Craig goes ahead and sees Dave's Bitcoin. One thing interesting about this complaint is that the plaintiffs here created to be the creators of Bitcoin as well. It says that both Dave Kleiman and Craig Wright together created Bitcoin. At least that's what the plaintiff alleges in this complaint. So jurisdiction, venue, why they can go in front of a federal court. All right, factual allegations. Let me give you a brief. So Bitcoin, you all know how proof of work works. You can get them either by mining or buying them on an exchange. History of Bitcoin. If you haven't read the white paper, you're already behind this game. You should probably read the Bitcoin white paper. Background on the parties. So here's some background on David Kleinman. He does a lot of crypto stuff. Blah blah blah. Ira is Dave's brother, personal representative. Dave and Craig's relationship. So this is how Dave and Craig Wright met in 2003. They met. Eventually, they started to work together and form WNK Info Defense and Research LLC. So I presume WNK stands for Wright and Kleiman Info Defense and Research LLC. So now there is a limited liability company that was supposed to have held all of the Bitcoin. So Dave owned a substantial amount of Bitcoin. I'm not sure what the current market value was. Last time I checked, it was floating up and give or take $1,000. So floating at around $10,000, give or take maybe $1,000 to $2,000, depending on market conditions. So between 8 and 12. The last peak was 14 about a month back. Don't keep track of the markets too tightly, just when XRP goes low. So after Dave's death, Craig fraudulently converted the Bitcoin and intellectual property that belonged to Dave. So in short, they set up WNK Defense and Research to mine Bitcoin and develop blockchain technology. So then here's the fraud. This is his real signature. This is the fake signature. Then this is them saying, hey, look, if you use Auto, which is a font, it looks like you just copied from this Auto. And then later on they admit that, but Craig Wright says, well, even though we used a computer to generate the signature, he was still the one who created it. Stipulates a value of 215,000 Bitcoin. I think the total they're saying around it's about 1.1 million Bitcoin total. So we already passed the default judgment. Yep, we did. Hold on. There's one part that I wanted to go over real quick. It was, here we go. Craig secures default judgments against WNK with fraudulent contracts. So the company, WNK, we'll call it WNK for short, Craig sued them in New South Wales Supreme Court. So, what is that? South Wales, I presume that's in Great Britain. A default judgment is basically, I told you have these two kids, they go in front of a teacher. You have kid A, and you have kid B. Kid A says, you stole my Legos, and kid B is supposed to file an answer saying, no, I didn't steal it, or even if I did steal it, it's not my fault, I don't owe them because something else happened. That's what you call an affirmative defense. But anyway, a default is, say, kid B doesn't reply at all. And so if he doesn't reply at all, the court will be like, well, this guy said you did this. Kid A, the teacher, judge says, well, you stole a Lego, so I'm going to say you didn't answer, so I'm going to go say you admitted that. That's what a default does. It admits the allegations in the complaint. And because of that, now you owe them whatever they say they owe you, or the court will grant relief based upon, those findings of fact. So basically, they said that, well, they secured a default, but they did so improperly. They never served them with process, and they filed a bunch of fraudulent documents. So Craig Wright went ahead and allegedly, according to this complaint, were based upon demonstrably false factual allegations. So to go over what was allegedly false. So then he reaches out to Ira to cover up the fraud. Craig reached out to Dave and Ira's 94-year-old father, Lewis, and wrote. So basically, Craig reached out to Lewis, Dave's father, and that's when everything started to catch up. So when I was like, hey, what's going on? He says, from the documents, it appears clear to see a systemic transfer of assets out of the company back to you, but you never mentioned any of these actions you were taking against W&K prior to contacting us. Like, hey, why did you take all this stuff? Now you're trying to get our approval or something from us? And then he said, Dave did the actions to make sure that the court signed off on what Dave and I planned. So he said, hey, if you keep quiet, I'll pay you. And then he never got paid. And then Gizmodo and Wired said, hey, Craig and Dave started Bitcoin allegedly. And then we get to the counts of relief. So I'm just going to quickly go over those. Again, this is a complaint. It could be different in the amended complaint, which would control over this. So you've got the first one, conversion, which is basically when you take something from somebody. In this case, most likely conversion. The second one they have is misappropriation. And basically that's when you misappropriate. So trade secrets, they're misappropriating. Now here's the interesting part. Plaintiff to demand judgment against them for all available damages, including exemplary damage, together with cost, interest, attorney's fees, pursuant to Florida 688.005. There we go. You get your attorney fee hook right there. That's what every attorney wants to see. Basically, a way to get money, because nobody works for free. We have an amendment against that. We had a civil war against working for free, so people like getting paid. For plebin, that's when somebody makes you give something back. You're basically, they took them and now you're getting them back. Breach of fiduciary duty. This involves W&K. So basically saying, hey, Craig had fiduciary duties of care, loyalty, and good faith. That's not very common in your basic business class. We call it conflict of interest. If you're the CEO or a partner in charge of a company, you have to act in the interest. You have a duty of care to the company and the shareholders, a duty of loyalty to the company and shareholders, a duty of good faith. You can't use your position of power to steer things in your own favor to the detriment of whatever that company is. So he's saying, hey, he had a duty of care, loyalty, and faith to Dave by virtue of their joint venture, and he breached those fiduciary duties and acted in his own self-interest. Allegedly. Don't sue me, Mr. And then you have a breach of partnership agreement, saying, hey, there was a partnership agreement here, and they breached it. You were supposed to. So valid partnership through their mining, when he legally transferred all the assets to himself. So he breached that partnership agreement. Then you have unjust enrichment. We call that quasi-contract. There's no actual contract in writing. I'm not going to get into the facts of it. It's an equitable remedy. They mined the Bitcoin, that it conferred a substantial benefit, and used that Bitcoin for his own economic and trade purposes. We call that a contracted law, basically. So there wasn't anything in writing, in fact, but for all intents and purposes, you were doing something, and so they'll say, okay, well, you've been unjustly enriched. It's when there's no breach of contract claim available you sue for an unjust enrichment. Water. So let's go over this order that the judge came down. So this is the basic complaint. You know what's going on. It's short, even though it's manifested in 6 different counts. Basically, we had Bitcoin, we mined it, gave the Bitcoin to a company, and Craig Wright took it. So give me my $10 billion in Bitcoin, my 1.1 million, 1,100,111 Bitcoin. I want my Bitcoin. So now in discovery, the judge goes ahead and says, hey, give everybody the information because we're going to have a trial, and at this trial I want this case to be tried on the merits. I want all the facts. So discovery is the process whereby each party, Kid A and Kid B, say, hey, get all your facts together. Kid A says, well, you took my Legos to Kid B. Kid B says, no, I didn't. Kid A says, yeah, well, I had a GoPro on me, and it showed you taking my Legos, and so I have a video of you taking my Legos. And the Kid B says, you have that video? Let me see it. I request you produce that video. Kid A says, well, no, I don't want to give you that video. The judge would be like, shut up. He requests you produce that video according to the rules. I'm trying to figure out what's going on. Give over the daggone video, so to speak. That's, again, just a very basic example. So let's go on to, that's enough for this for now. The order. Let me just get rid of this too. Order on the motion compel. So basically, they've been trying to get David Kleiman. Ira is representative of the estate of David Kleiman, and WK Info Defense Research. So you can see there's an extra plaintiff added here. That was most absolutely one of the things done in the amended complaint, adding another party. But anyway, so in short, the plaintiffs have been trying to get discovery from Craig Wright. And for the past, since at least January, so 9 months, Craig Wright has not been providing discovery. And the judge was none too pleased with this. None too pleased. Judge or magistrate? Oh, so magistrate. We're not going to go into that, but judges are nominated. Magistrates act basically as judges, and then the judge reviews what they did and signs off of it. I don't want to say mini judge because it's disrespectful, but magistrates, for all intents and purposes, act as a judge. The magistrate basically helps. There's so many cases that magistrates are chosen to help the judges rule on the cases, and then the judge can go ahead and say, well, this is what the magistrate found. I either agree with it or I disagree with it, so I'm going to, generally speaking, judges agree with magistrates' orders because magistrates take their jobs very seriously, and so do judges. So I will just go ahead to the applicable legal principles. When you don't comply with discovery, this is some of the things a judge can do. So basically, the court may impose sanctions that affect further litigation on the merits. So in addition to getting attorney fees, so you can directing the matters embraced in the order or designated facts be taken as established. So the court can say, you're not providing discovery. Because you're not providing discovery about facts, I'm going to consider this fact established. Prohibiting disobedient parties from supporting or opposing designated claims or defenses, or introducing designated matters into evidence. So you can say, all right, well, you don't want to give information about this stuff. Well, your defense depends on it. You can't give any information on it. You said you're not going to produce it. All right, well, you can't give any information on that. Striking pleadings. It's a very one. Basically, you have that complaint and answer. If you're the plaintiff and your complaint is stricken, your case is dismissed. You lose. If you're a defendant, well, this is if they do it in whole. If you're a defendant and your pleadings are stricken and whole, it means a default's entered against you, and basically you lose. They just get to prove damages. Actually, facts were established, and part of defenses were stricken for plaintiffs, so this is pretty big. Staying further proceedings, dismissing, that's part of striking pleadings. Rendering a default judgment, part of striking pleadings. So if you want to read this, it's publicly available. I got it from a publicly available source. However, you can also go to Pacer and download it yourself. This stuff is pretty good, though. Fourth, I impose the following sanctions pursuant to Rule 37B. So for purpose of this action, it is established that 1. Dr. Wright and David Kleiman entered into a 50-50 partnership to develop Bitcoin intellectual property and mine Bitcoin. Second, that any Bitcoin-related intellectual property developed by Dr. Wright prior to David Kleiman's death was property of the partnership. That all the Bitcoin mined by Dr. Wright and David Kleiman was property of the partnership, And then fourth, plaintiffs presently remain in ownership interest in the partnership's Bitcoin and any assets traceable to them. To conform to these established facts, the court strikes the third affirmative defense, fourth affirmative defense, fifth, sixth, seventh, eighth, ninth, technically, because they said seventh twice, and 10th affirmative defense. So a lot of his defenses were stricken and certain facts established. There is one part in this order, I don't recall exactly where it was, but the judge says, I don't find the sufficient evidence necessary to state who, in fact, invented Bitcoin. I can't find. Here we go. Two preliminary points. First, the court is not required to decide. It does not decide whether defendant Craig Wright is Satoshi Nakamoto, the inventor of the Bitcoin cybercurrency. And second, the court is also not required to decide. It does not decide how much Bitcoin, if any, Dr. Wright controls today. So, in short, he's saying, well, we don't know who Satoshi is, and I'm not making any findings about that. Going back to the complaint, I hope I didn't get rid of it. I did get rid of it. Just a second. Let me pull it back up. Right. Complaint. So what were the facts that were established in this? It was... We go back down. Where is it? There was a partnership. Any Bitcoins mined prior to David Kleiman's death was part of that partnership. All the Bitcoin mined is part of the partnership when mined, and then that plaintiffs have an ownership interest. So if we go back to our complaint, we've got our, what was this, 6 counts. So for instance, this isn't a secure way. It's not that they've gotten judgment yet. So for instance, they haven't completely proved any of these counts yet. They've just done the first few elements, so conversion. So Dave lawfully mined. They haven't proved, he unlawfully and without permission converted. They haven't proved the conversion, but they did prove the fact that there was a partnership and that all the Bitcoin were split 50-50 halvesies between Dave and Craig. Again, going on to misappropriation. Trade secrets. I'm not sure what those are. I haven't looked at the exhibits, so I'm not going to go too much of that. Replevin, which is give back the Legos, i.e. the Bitcoin in this case. They had a lot of Bitcoins, and he took them, and so now they want them back. The court didn't say Craig Wright was Satoshi Nakamoto, and the court didn't say how many, if any, Bitcoins Craig Wright presently has. He didn't make any findings to that. However, he did find that there was a lot of Bitcoins. 1 million out of 21 million. That's 1/21th. Whatever that comes out to, slightly under 5%, something like that, of all Bitcoins in existence. That's a lot of Bitcoin. So at $150 billion market cap, that's you can do the math there, whatever current market price it is. And then we've got breach of fiduciary duty. This is basically a way for the company, W&K, to get those Bitcoins back, or at least the financial equivalent damages and or return of the wrongfully taken Bitcoins. These are very similar overlapping counts. Breach of partnership agreement, demands judgment for purchase of his partnership interest. So basically, I want my half of the partnership. And unjust enrichment, we look at it, plaintiff demands against for the value of the wrongfully retained Bitcoin and intellectual property. I'm not sure what intellectual property they have. Craig Wright is supposed to have some. So it's W&K. I'm not sure as to what exactly that, those intellectual property or trade secrets are. But again, this order was a really, really big blow insofar as now they have affirmatively approved that The judge has found and will now stick to his guns that there was a partnership. The IP, I guess I should just read. The IP related to the Bitcoin related IP is property of the partnership. The Bitcoin is property of the partnership, and the plaintiff presently retain an ownership interest in the partnership. And any asset traceable to, on a proof of work blockchain with traceable evidence, proof of work, the ledger that goes all the way back. It's pretty hard not to follow that. Again, this discussion part is absolutely hilarious, though. Dr. Store not only was not supported by evidence, it defies common sense and real life experiences. There's a movie, The Princess Bride. Inconceivable. Yeah, definitely. It's filled with things like that. So the court's not buying it. It says that Dr. Wright was acting in bad faith and purposefully stalling the litigation. So it was just like, all right, I'm going to go ahead and say that you're doing this purposely, and because I don't believe you, the 1.1 million bitcoins, how many ever were mined? He didn't say exact amount, and that belonged to the partnership, and they have part of it. Now that's whether or not he owes for conversion, or let me see, what are some of the other ones? Conversion, misappropriation, replevin, breach of fiduciary duty, breach of partnership, or unjust enrichment. That remains to be seen. But this is a real big victory for the plaintiffs, at least on these findings of fact. Well, that's it for now. I will go over the amended complaint a little bit later. The big things to remember here are, again, you've got, pleadings is how a case starts. You file an answer. Then you've got discovery, where the court's trying to get, all the information. And then you've got the trial, where the parties get to present all their information to the judge. So that will be very useful for us later when we look at the Ripple Labs case, if you're interested. I will probably do another video on the amended complaint. Here's a small preview of so far the Ripple suit. I pulled the docket again today, even though I also pulled it last week. You can go ahead and see that an amended complaint was filed. Day 5, generally speaking, there's 19 days to respond, so they are cutting it close by having not filed a response yet, though. I have a feeling a motion to dismiss is coming soon. I'm actually almost certain or positive it'll be a motion to dismiss, or a motion for more definite statement. We haven't even gone over the attorneys here, but we'll do all that later, and that's for another time. So anyways, this is Paul Godfrey. Hopefully you've enjoyed this little bit of information on Craig Wright case, and soon we'll be hitting up the Ripple Labs case. Was an XRP holder and Bitcoin holder. All this is very interesting to me. I've got a number of digital assets. I'm not trying to brag, but there's a fairness and disclosure. I don't want you to think I'm unbiased in writing in this. I do have my own interests here, but this to me just as itself, these cases are interesting. So if you like it, go ahead, like, subscribe, and I will continue posting these videos. Let me know if you have any suggestions or any comments, and hopefully, we'll get through this stuff. Thank you so much, and have a good night. Also, one last thing, Hurricane Dorian. I'm in Florida. Fortunately, it'll miss us, but be safe out there, everybody. This is a pretty big hurricane, Category 4 last I checked, so got downgraded from 5, but fortunately I'll be safe, but not everybody will be so lucky. So have a good night, y'all.